If you run a small business in Alberta and one of your employees has recently approached you about accommodating their illness in the workplace, you may be wondering how you need to handle this situation. I'm Mike with Cashion Legal, and we're an employment law firm based in Calgary, Alberta. In this video, I'm going to share 5 things that every Alberta-based small business should know about accommodating illness in the workplace. While this video is not a substitute for legal advice, at the end of this video, you'll have a better understanding about how you should handle these situations with your small business. Before getting into the legal considerations, I think it's worth pointing out why accommodating illnesses is a good thing for any small business to do. By properly accommodating employee illnesses, you're more likely to build loyalty with your employees and foster a positive workplace culture. If you mishandle an accommodation process, that creates a risk that you might lose an employee that you might not otherwise lose. That presents all sorts of significant costs for your business, including lost recruiting time, lost training time, and loss of institutional knowledge. Also, handling these situations properly will increase the morale of your team. Employees notice how their colleagues are treated when they're going through a difficult time, so when people see that you're treating people properly, that will reinforce their willingness to do a better job in the workplace. So getting accommodation right is not just a legal obligation, but an important part of fostering a positive work environment. With that being said, let's get to the 5 things that you should know about accommodating workplace illnesses in Alberta. Point number 1 is that you should know the basic entitlements that employees have under Alberta's Employment Standards Code. Under the code, any employee who's been employed by the same business for more than 90 days is entitled to up to 27 consecutive weeks of unpaid sick leave. If an employee provides you with a doctor's note confirming that they're not able to work due to illness, and the note confirms an anticipated return date, that employee is then entitled to take sick leave. When it comes to accommodating these requests under the code, you're not allowed to request any more information than that. Additionally, while this employee remains on leave, you're not allowed to terminate their employment, except for in very exceptional circumstances. This is a basic statutory right that every employee in Alberta is entitled to. However, this is not the end of your obligations to employees who are dealing with illnesses. The second thing that you should know is that the illness might qualify as a disability under Alberta's Human Rights Act. While not every illness qualifies as a disability, if the illness is sufficiently serious, then the employee is entitled to protections under human rights legislation, which go well beyond the protections under the Employment Standards Code. There is no clear bright line as to whether or not an illness is a disability or not, but one way that courts have put it is whether the illness prevents the individual from fully participating in society. Another way that the issue has been framed is whether the illness has a sufficient severity, persistence, and permanence. Because there is no bright line test as to whether an illness qualifies as a disability, in most cases, it's better to err on the side of caution. The third thing you should know about accommodating illness in the workplace is that your duty to accommodate might be triggered even where the employee doesn't request accommodation. An employer's duty to accommodate under human rights legislation is not only triggered where the employee requests accommodation, but in any circumstances where the employer reasonably ought to know that accommodation is required. For example, if you have an employee who very clearly is suffering from an illness that inhibits their ability to contribute to the workplace, you have to accommodate that employee's illness even if they haven't specifically requested the accommodation. So if you know that someone is sick and it appears that the illness is impacting their ability to do their job, you do need to take positive steps to make sure this person is okay and that they are in a position to fulfill the expectations of their role. The fourth thing that you should know is that where there is a duty to accommodate, you are entitled to request reasonable information in order to facilitate the accommodation. This is different from the Employment Standards Code, which sets very strict requirements about what employers can ask for when dealing with employee illnesses. In the human rights context, you can request whatever information you reasonably require in order to facilitate the employee's participation in the workplace. The amount of information you can ask for differs in every set of circumstances. Like if someone's just requesting time off, then you don't require very much information. But if they want to show up to work and have to have special accommodations for how they carry out their role, then you might need more information in those circumstances. The fifth and final thing you should know is that simply allowing someone to use their sick leave under the code does not exhaust your duty to accommodate. As I explained earlier, Under the Employment Standards Code, every employee who's been with the same employer for a period of 90 days is entitled to up to 27 weeks of consecutive unpaid sick leave. And while you cannot terminate someone's employment while they are taking that sick leave, that does not mean you can simply terminate them at the end of that sick leave. That's because under Alberta's human rights legislation, you have to show that it would be an undue hardship to continue to employ that person on unpaid leave following the end of that statutory period. This means that you have to demonstrate that there is some sort of significant burden on the business of keeping that person in a formal employment relationship. In fact, there is no hard and fast rule about when exactly you can let someone go if they've been away from work for an extended period of time. However, if it does reach the point where there is no reasonable prospect of the person returning to work, then you can claim that their employment contract has been frustrated, which discharges your obligations to that employee. If your business is currently handling an illness-related accommodation request and you're wondering how to navigate the situation, we can help you. As I said earlier, we're an employment law firm based in Calgary, Alberta, and we help small businesses navigate accommodation requests by providing them with clarity about their circumstances, strategies for navigating the situation, and peace of mind through sound advice and strong representation. If you find yourself in this situation and you're looking for assistance, or if you need help with another employment law issue, you can connect with the team at Cashion Legal through our website.